Good morning, everyone. My name's Helen McIntosh, and I'm the president of the South East London Chamber of Commerce. We're delighted this morning for our webinar to be hearing from two paralegals from Woodcock Law, and the subject today is skilled workers visas. I'd like to introduce everyone to Roshni Shah, who I can see at the moment, with very elegant long hair, and then Papia Kabir, the ladies are going to give the presentation. What I would like at the end, if you can save your questions to the end and then put a little yellow hand up and they'll be answered. Okay, so over to you, Woodcock Law.
Thank you. Thank you very much. We are just going to start sharing our screen. So thank Helen for the kind introduction. So you should be able to see our screen. I will just minimize all guests for now. So as Helen mentioned, today's webinar is being held in conjunction with South East London Chamber of Commerce, and today's webinar will be focusing on the changes, updates and guidance to the skilled worker visas as of 2023. This year has been quite a big year in terms of immigration for the skilled worker route, and there have been quite a few changes made in the statement of changes published by the Home Office, and also this has been reflected in appendix notes as well. So today's webinar will be a cohesive roundup of the main changes and we will be taking it forward from there. So this webinar will consist of 3 segments. The first segment will be looking at the skilled worker application in its entirety and the main changes which have happened. The second section will be focusing on 2 case studies. Both myself and Roshni will delve into a case study that both of us have been working on as a live case, just to give you a bit of an insight into the type of cases that we do work on and how they have been affected by the changes and how we have overcome it. Just because if you have joined this webinar, you are in a similar position or you're looking to get some help, it might give a bit of perspective into what we do as paralegals at Woodcock Law. The third and final section will be tailored more to the sponsor license holders that have joined this webinar today or are watching this on a recording, just because as well as changes being made to the actual skilled worker route, this does heavily impact the sponsor license holders, just because it does change what you need to do as your requirements in line with Home Office rules. So as I mentioned, 3 separate sections which will be hosted today by ourselves. As mentioned by Helen, this webinar is recorded as well, so if you did want to catch up, feel free to watch our recording and do get in touch with us. Just gonna go to the next page. Okay, so just by way of introduction, as Helen mentioned, my name is Papia. I am a paralegal here at Woodcock Law and Notary Public. My areas of specialism are in the skilled worker route and more closely with the sponsor license application. So I am the main point of contact for companies and small organisations looking to obtain a sponsor license here in the United Kingdom in line with Home Office rules and regulations. Once obtained, I then work with our clients and with the wider legal team here at Woodcock Law to then assist with the skilled worker application. There are other visa routes that we do assist with, so if you have joined and you are looking at other visa routes, do again get in touch. I will let my co-host also introduce herself.
Hi everyone, my name is Roshni. I am also a paralegal here at Woodcock Law and Notary Public. I have been working here for 2.5 years now, and I do specialise more on the skilled worker front. As Papia said, she specialises more on the sponsor licence, so I then take the process there forward. So without further ado, we will go further into the presentation, and we will discuss the skilled worker visa and the changes that have been made this year. So just a little bit about what we do here at Woodcock Law and Notary Public. As I mentioned, we are an immigration law firm. We do offer services in personal immigration and business immigration. As well as being an immigration law firm, we do offer notarial services as well as legalisation and apostille. So our main principal solicitor, Nathan Woodcock, he is also a notary public. So if you do ever require notary services, please do let us know. We do also offer visa and consular services as well as ITIN services. We do currently have 2 CAA agents working for us, one of them being Papia. But yeah, that's just a little bit about what we do. And if any of this does seem of interest to you, please do let us know after this presentation.
On the screen as well, you can see our accrediting body. So we are accredited by the Solicitors Regulation Authority. So all casework that is held is done in line with the SRA rules and regulations. And just a quick note before we do start this webinar, we are offering all attendees to this webinar a special code, which will be put forward towards the end of this webinar. So do stay until the end, just so you are entitled to the free consultation for all webinar attendees today. So without further ado, we will just hit off with the webinar today. So firstly, if you have joined this webinar and you're either unsure about what the skilled worker visa is, or you've done a little bit of research, what we will do is we'll go through the specifics and the background for a skilled worker visa, because it's always good to know what the visa is in its entirety. As I'm sure a lot of you do know, the Home Office have released several visas across the years, and there are various modes that you can go through in terms of visa opportunities. So as this webinar will be based on the skilled worker visa, what is the skilled worker visa? So the skilled worker visa is currently the most popular route for migrant workers to enter the UK. It is very popular amongst students who are looking to switch over to the skilled worker visa upon completion of their studies, and also graduate visa holders who have finished their studies, are on a 2-year visa, and are looking for another way to remain in the country and continue working in the country in line with Home Office rules and regulations. The skilled worker visa is it is a 5-year, so the route that you can go down is either 3 years or 5 years, 5 years being the maximum that you can get on this visa route. Our personal recommendation has always been the 3-year route, just because this is less likely to get flagged up by the Home Office, especially amongst all the changes that have happened in 2023 with the skilled worker visa route. So under the skilled worker route, and once you're granted, the main thing that you do need is you need to have a UK sponsor who is looking to sponsor you and assign you a certificate of sponsorship, as this is one of the key elements needed for the skilled worker visa, along with other requirements, which we will go into in just a few slides. But once obtained, the skilled worker visa does allow you to stay for the duration of your certificate of sponsorship. So again, that could be anything between 1 year to 5 years. Typically, it is 3 year for the period. After the 3-year route, most individuals do look for an extension to hit up the 5-year mark. And after the 5 years, most skilled workers do then go on to do their indefinite leave to remain application. And then following that, naturalisation, if they are looking to permanently settle down in the UK. So the skilled worker visa is a great basis to start the continuous residency requirement of staying in the country for a minimum of 5 years continuously. So the skilled worker visa is very, very popular in terms of future planning for your immigration route, and also for security in terms of work. Again, the skilled worker visa can be offered to someone overseas. So a lot of sponsor license holders that we currently work with look to hire individuals from Nigeria, India, China, the Philippines, quite common countries that we do assist with to bring over individuals to work in the UK. Alternatively, as I mentioned, you can also hire someone who's already in the UK, but they need to make sure that they are on the appropriate visa where they can switch over. So again, further details will be provided throughout this webinar about this.
Okay, so just moving on, the first thing that we like to do when we do receive a skilled worker visa inquiry is we do like to complete an initial screening. So what we do is we like to ensure that you are eligible for this route, and by doing this, we check all the documents that you currently have. We check your level of English that is required for this particular visa application process, and whether you have a certificate of sponsorship. So you will see a few things on your screen. Again, it says certificate of sponsorship, sponsor license, correct salary requirements. So just going into that a little bit more, what we like to do is many companies do already assign a certificate of sponsorship before they come to us, and then they ask us to assist with the actual application. One thing we do want to flag is that we do assist with the entire process. So we do assist with assigning the certificate of sponsorship. However, if you have assigned this already, that's not a problem. What we like to do is we do like to ensure that the correct stock code has been selected for that route, and that they have been provided with the correct salary, because if this is incorrect, this is something that will get flagged by the Home Office. So it's absolutely crucial that this is correct and in line with the Home Office requirements. Another really important one on your screen is the proof of English language. So this is actually one of the main documents for this application cycle. And we have seen this get flagged on many occasions when individuals haven't had the correct level of English as specified by the Home Office. So the main requirement for this is that you complete an IELTS for UKBI general training test at level B1. You are expected to obtain a minimum of 4.0 in each component, so that being speaking, listening, reading, and writing. Anything less than this will get flagged, and it is likely that the application will get refused. So again, this is something that we do assist with, and if you haven't completed your English language, it is something that we can assist with booking the test on. And if you already have a degree that's been taught in English, again, that is something that can be used, but we would need to discuss this further, depending on where the degree was taught. Another thing that you would need to provide, depending on where you're applying from, is a TB test. So again, this is something that we can determine during the initial screening. So certain countries such as Nigeria, India, China, they all require a TB test. There are some countries that are the exception to this, so you wouldn't need to, such as the UAE. You don't need to provide a TB test for that country. Another thing is if you've already been in the UK for more than 6 months, you will also not need to provide a TB test. But again, this is something that we would need to determine during an initial screening. As Papia mentioned in the beginning, we are offering a free 30-minute consultation to all SELT members. So if the skilled worker visa is of interest to you, please do come to us. Please do let us know so that we can complete the initial screening on our end.
As you can also see on the screen, we do help to apply for both a certificate of sponsorship and a sponsor license. As caseworkers, me and Roshni are always inundated with inquiries from potential clients who are looking to obtain a skilled worker visa. It is something that I would like to stress at this point. You do need to have a UK sponsor in place. We do have a lot of inquiries where we do receive information from the candidate, and although they meet all the requirements that you can see on the screen, the main thing is they don't have a sponsor ready to sponsor them. And unfortunately, we are not a recruitment agency, so it isn't something that we can advise on. So it's always important that when we do get these initial inquiries, that we can ensure that you do have a sponsor license holder ready to sponsor you and ready to assist you with the process. So again, if you have joined this webinar, you're watching this on recording, and you are interested in the skilled worker route, please do ensure that you have met all of these requirements, but most importantly, you have a sponsor ready to assist you with this process. If you are in a situation where you know an individual who, potentially is looking at a sponsor license but is yet to obtain one, and you're looking to do both the sponsor license route and the skilled worker route, this is something that I assist with on a bespoke case-by-case basis, just because then we can assist with the timeline and make sure that everything is mapped out to ensure both the company and the individual are ready in terms of immigration and in terms of the application submission cycles. So again, we can help apply for both of those aspects if that is something that you are looking forward to. Okay, moving on to the salary requirements. So this is quite a big aspect of the skilled worker route, and this is one of the biggest changes which have come into effect as of 2023. Previously, the salary was lower than this, but the Home Office have increased salaries across the board, and the minimum salary right now under Tradable Points A is 26,200 per year for a 37.5-hour working week. So typically, and again, we'll be going through this in greater detail just because, as I mentioned, the salary is such a big part of the skilled worker application. Not meeting the salary requirement can flag up to the Home Office an inadequate application and provide grounds for refusal, which is something we at Woodcock Law try to avoid from the get-go, which is why we do the SOC code mapping process to make sure your salary is in line with the correct guidelines. So whilst it is a minimum salary of 26,200 per year, this again is affected by quite a few things. So it depends on the SOC code. So each SOC code, which we'll go into in greater depth in a while, is the 4-digit code that's assigned to each job posting. And each SOC code has its own going rate. So this can be 26,200 or greater. Most situations, it is the higher amount. Some situations, it can be the lower amount. So there are some SOC codes out there where the going rate is 21,000. But again, with the skilled worker route and appendix skilled worker, you need to make sure that you, A, meet the 26,200 threshold, as well as a going rate. So whether that's the higher amount or the lower amount, both of those need to be exceeded. And a big thing that I do want to stress on this part of the webinar is the hours that you work throughout the week do impact the salary that you you are given. So we can offer you a pro rata service where we can go through your salary and make sure you tailor make it, because we have a lot of clients who do come to us. 37.5 is just not ideal for their business, which is completely understandable. There are companies out there that wish to do a 40-hour week or a 39, which are the two most popular ones after 37.5. So if you are in that position and you need to make sure your salary is correct, do get in touch, because we are able to advise from a immigration point of view whether or not that salary is meeting the threshold, because again, the last thing you want is to be flagged up for your salary not being correct. Okay, so as I mentioned before, this is just an example on screen just to contextualize what I've just mentioned, just because it is a very much a theoretical point of view that we've just spoken about it. But for example, as on the screen, if the director was being paid 8,000 and that was on their SOC code, so that was a going rate for their SOC code, you would need to make sure that you're fulfilling that 80,000 for the 37.5-hour working week, and also you wouldn't be able to pay them the minimum of 26,200. So you need to make sure you're meeting both of those requirements. Again, with the Home Office, all of their going rates are based off 37.5 hours per week. So that is something to bear in mind. So all of the going rates are accommodating that particular set of hours for the week. So if you are looking to increase the hours or decrease, then that is a different conversation that we need to have. And as I mentioned earlier, at Woodcock Law, we do base each application on its own merits, and it is a case-by-case analysis that we do just to make sure that that specific individual is equipped with the right skills and salary to make sure that their application can be granted. Again, if you do have a specific question about the salary, we will be hosting a Q&A session at the end of this webinar, and also all SELP members will be eligible for our free 30-minute consultation that we have.
Okay, so just touching upon what Papia mentioned regarding the minimum salary for the skilled worker visa under Tradable Points A, which was 26,200. It is important to note that there are situations in which that 26,200 will not apply. So the minimum salary can go down to 20,960, and this is dependent on which tradable points you fall under. So, for instance, if your job is on the shortage occupation list, so if your job is in high demand, there is a specific list that you'll be able to follow, and the minimum salary for this will be 20,960. Another instance in which your salary requirement will reduce is worker has a PhD relevant to the job, or they hold a relevant STEM PhD. Another instance as well that we see quite often is individuals who are on the student visa. So the minimum requirement for them is a lot lower, and they need to have 70% of the going rate. So that would be 70% of the 26,200 to meet the requirements. So it's not that there is a 26,200 across all tradable points. It does differ, and it does vary depending on your situation. And again, as Papia mentioned, if that is something that you would want to know a little bit more about, we are hosting a Q&A at the end of this webinar. So please do shoot any questions that you have towards us, and we should be able to respond accordingly and assist you with that.
Okay, so in line with the 2023 changes and initial requirements, as mentioned earlier on by Roshni, this is part of our screening test that we do, just to make sure that you do have the right requirements and documentation at the start of the process. But the initial requirements are made in line with Appendix Skilled Worker. So I understand this might be a bit of legal jargon. So Appendix rules are released by the Home Office. And this is effectively a checklist that caseworkers go through when they are assessing an application, as you need to make sure that you are meeting the rules and requirements for that appendix. So each visa category does have its own appendix rules. So under Appendix Skilled Worker, you need to make sure that the following requirements have been met. So again, firstly, the funds made payable for the application. Again, with the Home Office changes of 2023 and in line with changes made by the government, there have been changes to the application cycle. So there are quite a few fees that you would need to pay for the application. Again, this is dependent on each case and based on each of your factors. So if you would like to know a full breakdown as of today's date for your particular situation, do get in contact. But just as a summary, for each application, you are liable to pay the Home Office your application fee for the visa that you submit, your immigration health surcharge, so that you can use the NHS for the duration of your certificate of sponsorship. In addition to this, you are also liable to pay for your certificate. So your certificate of sponsorship, there is a fee payable either by the sponsor or by the applicant. Again, that is a discussion you would need to have between yourselves, and the fees will be payable directly to the Home Office. When making your certificate of sponsorship fee, you also need to pay the immigration skills charge. This is a fee typically paid by the sponsor, but again, it can be distributed within internal talks with who's going to pay the funds. But again, those fees will need to be paid directly to the Home Office in addition to our professional fees. Again, the reason why we haven't disclosed the fees right now is because they can depend on whether you're in country, out of country, the length of your certificate of sponsorship, whether you're on short-term occupation, what your SOC code is. So as you can tell, there are quite a different few factors which do vary the funds payable for the Home Office. So if you do have a specific question about that, do get in touch. In addition to that, as part of the initial requirements, you do need to show and meet the financial requirements as a skilled worker. So this is either through money that you can support yourself, so by your bank statements, or in most cases, a certificate of sponsorship. So there is an option to tip for maintenance. So that is the sponsor certifying maintenance so that they will look after you and your dependents when you arrive in the UK adequately. And this is what we usually advise to each of the sponsors based on their business portfolio and business profile and how long they've had their sponsor license for. So again, a case-by-case analysis would need to be done. Again, initial requirements, you would need to make sure that you have a job on the eligible occupations list, and we will be going into that in a bit more detail shortly. And as this is a points-based immigration system, appendix skilled worker does fall under the point, so you need to make sure you are acquiring and obtaining 70 points throughout your application cycle. And this is where our team does offer a cover letter in support of your application to evidence how you have met those points in our understanding of your documentation, as well as the evidence that we can supply to the Home Office. And as Roshni touched on earlier on, you do need to show proof of English. Okay, so with the points-based system, as I mentioned, this does fall under Appendix Skilled Worker. So as per Appendix Skilled Worker, you need to show 70 points in total. The 70 points are broken down into 50 mandatory points, and 20 remaining points come from the tradable sources. So I'm just going to go into those in a bit more detail.
Okay, so I will just go through the mandatory requirements. So the 50 mandatory points that you're required to obtain for the skilled worker visa. So 10 points come from your level of English as required. So you do need to have, again, a minimum level of B1 for the skilled worker visa. And that is a score of 4.0 in each component. So again, speaking, listening, reading, writing. One thing we have seen quite a lot is where individuals have obtained an overall level B1, but in one component they've obtained less than 4. It is important to note that whilst there is a requirement for a level B1 altogether, it's not sufficient if you've obtained less than 4.0 in any of the components. That will get flagged. And again, because this is a main requirement for the Home Office, this is likely to get flagged or furthermore refused. So again, that's something that we like to check quite thoroughly on our end. And it is something that we address in our further representation letters just to avoid it being flagged later on. The other 20 points will come from the job being at an appropriate skill level, and then a job from an approved sponsor. So one thing I do want to flag up here is, whilst there is a total of 50 mandatory points, if you have obtained 40 of those points and you haven't met the English language requirement, the application will get refused. You do need to have all 50 points. And if you want to know whether you've met that requirement, please do let us know, because again, that's something that we do check as well, especially in our initial screening. So it is really vital that you have that call with us and we can check that on our end before you proceed any further, because of course there's no point proceeding with an application, paying all of the Home Office fees, and then the application being refused.
Okay, and the latter part of the points-based system and 70 points is made up of the tradable points. So as you can see on the screen, there are 6 categories that you could fall under. So what we do here at Woodcock Law as part of the cover letter process and as part of the process from the certificate of sponsorship stage is we do try to assign you with the correct tradable points. So the most popular tradable points is option A. This is an individual who has met the threshold of 26,200 and also the going rate for their SOC code. So this is the most typical one that does get used by ourselves, just because most individuals do meet that threshold. Again, if you don't meet tradable points A, we do then consider other tradable points. They do have equal weighting. It's just you need to choose a best fitting one for the Home Office caseworker, because as I mentioned earlier on, they do use a points-based system as a mark scheme effectively, to see whether or not that individual has met the requirements and whether or not they would meet all requirements across the board for the skilled worker visa. So our job is to make sure that you do meet the requirements in terms of tradable points, and that we assign you with the correct point system on our end. So if you don't fit tradable points A, usually the most common one after that would be tradable points D. That is for anyone who's on shortage occupation. So again, this is a common one, especially for those working in the IT industry, just because there is a shortage in the UK, and therefore these individuals can pay a lesser amount in terms of salary for the employer. And again, you do benefit from having that individual work for you, just because again there is a shortage in the UK, hence the name shortage occupation. Again, another common one is option E. Option E is available for those who are new entrants to the labour force. So typically you'll find those are under the age of 26, falling under this category. And again, they do benefit from having a lesser salary, just because they do fall under one of these tradable points that require that. Again, new entrants can be evidenced by their passport. This option is also available from those switching over from a skilled worker visa or a graduate visa, and they are able to benefit from the lower amount of salary, which is 20,960, or the going rate for that occupation code. But again, it's capped at a certain percentage. The final tradable points, which is quite common, is tradable points F. This is for those who are on the health and care worker visa route and they are being sponsored in a job in an eligible health code. So again, what the team does do is we make sure that you are being put in the correct tradable points category. You can only, and in our experience, we choose the strongest one. So for example, even though you might be a new entrant and your job might be in the shortage occupation, we will make a formal analysis and a full thorough review with the principal solicitor to confirm which tradable points would be the best for you. And again, we would just only analyze one and make sure that you are being put down for the correct tradable points, so your application has a best chance of success.
Okay, so just touching base on the standard occupational classification. So something you might have mentioned, or that I might have mentioned throughout the webinar, is SOC codes. So what I want to specify at this stage, and again, this is something that we tend to do either during the initial screening or just after, depending on whether you have selected us to represent you with your case. Each job will have its own SOC code. So for instance, there is the business development management one, and that's a very common one that we see being used. That falls under 3545. So there are specific SOC codes for each occupation that you'd be working in. One thing I do want to flag up at this stage, and you can see it from the screen in front of you, not all jobs that have a SOC code are eligible for a skilled worker visa. So what this essentially means is that whilst every job will have its own SOC code, it might not be that it's specific to the skilled worker visa. So there are other applications similar to the skilled worker visa and fall under that category, such as a senior or specialist worker visa or a health and care visa. So all of these will have its own SOC codes. It's just that you would use a different application to apply for that particular visa.
Just adding to what Roshni said, so the SOC code, and again, they are a 4-digit number. So as you can see on my screen, we have included a screenshot from the Home Office website, which is available to all members of the public. And this is what we use as caseworkers when assessing and going through the SOC code mapping process. So this is an example taken from the shortage occupations page. So as you can see on the left, we have the 4-digit code, then we have the job type of which code it falls under, and again the annual salary is always recommended by the Home Office. Again, just to stress, the annual salaries that are provided and the going rate are based on a 37.5-hour working week. So if you are looking to hire someone who is going to be working, for example, 40 hours per week, or you are the skilled worker and you know that that is what your employer is offering you, we would have to do a pro rata calculation on our end just to make sure that you are still meeting the requirements.
So a really common switchover that we see, and as Papia mentioned previously, which falls under tradable points E, is switching over from the student visa to the skilled worker visa. Now, this sounds pretty straightforward because it is one of the visas that you can switch over directly onto a skilled worker visa, but there are some requirements. So as you can see from the screen, the worker must complete their course and their job start date must be after the course has finished. So you can't start your new job with your sponsor before you have completed your course, and it is really vital to note that. Currently, the guidance is that you are able to withdraw from a course and then apply for a skilled worker visa. However, if you do, you will no longer be considered a new entrant. You will fall under tradable points A. So there is a slight difference in switching over directly from the student visa as opposed to withdrawing from the course and then switching over. For PhD students, it is slightly different. You can switch after 24 months of study, so you don't need to wait for the entirety of the course to pass. So what you'll see here is from 1st of January 2024, there has been some guidance released, and that is that students will no longer be able to switch to work routes partway through their course. So where individuals are withdrawing from their course or they fail their course and then they want to switch over, they will no longer be able to do that. So it is really important to note that as of January 2024, there will be strict guidance regarding this, and you will not just be able to directly switch over.
Okay, so that does conclude our first part of the webinar, where we have divulged into the skilled worker visa and quite a few components which do make up a solid skilled worker visa for the Home Office. So as part of this section of the webinar, we will be focusing on a few case studies just to put into perspective some of the things that we've spoken about. And if you are one of the attendees or you're watching this on recording, if you do feel like you are one of the individuals that you can see on our screen that we've worked with, or you have a question about your own situation, again, do feel free to get in touch. So my case study is actually off the back of what Roshni just mentioned. So I was contacted by an individual who was a current student in the UK, and her degree wasn't finishing until January of next year, so 2024. She had informed me that early July she had already put in an application for a skilled worker visa, but she had received my contact details from another individual that I'd been working on in terms of their immigration matter. She got in touch with me in light of the new changes, and as she had been reading a few news articles. Upon review of her entire case file and submission with the principal solicitor, we had noticed that her submission would be affected by the new changes that were made in appendix shortage occupation and appendix skilled worker, and she would actually fall under the new individuals and the new guidelines by the Home Office, whereby she would need to finish her course of studies prior to doing that skilled worker changeover. So unfortunately, we did have to have a full consultation with this individual, advise her that that application that she had submitted by herself would need to be withdrawn until further notice and until she had finished her studies. Because although her BRP was ending in January of 2024, her actual studies only concluded in September. So currently we are working with that individual to resubmit a fresh application for the skilled worker route, as she is and has finished her studies and is currently working towards graduation. So she was a key example of someone who was affected by the changes, the statement of changes released by the Home Office, and the changes in conditions which students now had to meet. Because typically before, individuals like that, we would have no problem with switching them over. It would just be a simple switch over from a skilled worker, from a student to a skilled worker. However, as she did fall under the cut-off period and with statements of changes with immigration, they are effective as of that day that they are published. So as they were released in mid-July, she did meet that threshold, and therefore the additional conditions did apply to her. And we did advise her that if she carried on with the submission that she had already done and she'd gone to her biometrics, her application would have been refused on the grounds that she did not meet the additional conditions. So as I mentioned, we are still currently working with the individual to get her new application in. Previous application has been withdrawn, so she doesn't have a refusal on her immigration matter, and we are working towards a submission once we have got the correct paperwork.
Okay, so the case study that I would like to flag, this is one that we've actually already dealt with and we have received an outcome for. So this one is quite common. It's something that we see happening quite a lot, especially in more recent times. So there was one particular individual who came to us for a skilled worker visa, and they had previously applied and had a refusal. So that wasn't an issue. We have seen that previously, and the main thing is that you address this in the application and state that they did have a refusal and why they meet the requirements this time round. We did that, but however, the application was flagged up by the Home Office. They did ask for additional information regarding the recruitment process that was carried out and why they were suitable for that particular role. So what we needed to do in that particular situation was provide a further representation letter. So we had already provided one with the first application. However, as there was an additional information request, we did one that was more tailor-made to the specific questions that were raised by the Home Office. In this situation, the individual hadn't gone a formal interview. However, they had an informal interview. So what we provided the Home Office with was a transcript of all the questions and answers that were asked. And then we also specified why they were suitable for that role and drew upon all their previous experience and their role previously for other companies, as well as any degrees that they'd obtained that were relevant to their qualification and the job that they were being sponsored to do. We did submit this within the very tight frameline of, I believe it was 5 working days at the time. And then we did get a successful outcome. So something I do just want to touch base on actually is it does happen a lot, and the Home Office do come down quite harsh actually on skilled worker applications, in the sense that they do like to know why that individual specifically is suitable for the role and that they are coming here to the UK to complete the role that they've been asked to essentially do. And one thing we do want to make clear, it's nothing to be worried about. It's just the Home Office doing their due diligence on their end, and as long as we tackle that within the tight frame line, then it's usually quite straightforward, and it is something that we see quite often. So if you ever do have a situation like that, or you're concerned about any situations arising in that sense, please do let us know, because that is something that we would be able to provide assistance on.
Okay, so moving on to the final segment of this webinar, we will be focusing more on the sponsor, who does assist quite heavily and plays quite a significant part as part of the skilled worker application. So as a sponsor, you do have access to the sponsor management system, or SMS in short. This allows you to make quite a few changes to the sponsor license in terms of certificate of sponsorship and what you assign to that skilled worker. So when you do start engagement with Woodcock Law, what we always ask for is authorising officer on the sponsor license to be engaged in that conversation from the get-go, just because we would be working very closely with that individual to complete the SOC code mapping process, to submit a draft of the certificate of sponsorship or the defined certificate of sponsorship, and to make sure that you are being compliant with the Home Office rules and regulations. So with the sponsor license, you are granted that for 4 years, and within those 4 years, and if you are sponsoring any individuals, you need to be making sure that you are doing regular audit checks on your individuals, making sure that any changes in migrant activities are being flagged to the Home Office within the 10 working day requirement. Again, if you have any questions about the sponsor management system, do get in contact with us, because it is a huge part of compliance. And again, the last thing you want once being granted your sponsor license is for that privilege to then be taken away due to poor management.
So just touching base actually on what you can do with the SMS system, as Papia said, this is absolutely crucial for monitoring your employee, especially if they're a migrant worker. It is something that you need to keep up to date with, because if you're not, your sponsor license could be revoked. So these duties do include assigning certificates of sponsorship. So as I mentioned previously, it is a part of the skilled worker application process, whereby you do need to assign a certificate of sponsorship to that particular individual that you're hiring. And this will basically detail where they'll be working, how much they'll be earning, and the job role that they are completing. You will be also able to use the sponsorship management system to assign a key personnel, so such as a level 1 user. And essentially this allows the level 1 user to assign the certificates of sponsorship, or inform the Home Office of any changes to the migrants' circumstances or their work. And you can use this again to report change of circumstances, such as an increase or decrease in pay, or change of working hours, or change of job role. So it is quite an important system that you need to stay up to date with. You can also use this to renew your certificate of sponsorship. So for individuals that are extending their visa in the UK by the same company, the company would just be able to renew the certificate of sponsorship on their end. And you would need to use this to upgrade and renew your sponsor license. So every 4 years, you would need to renew your sponsor license. And the way in which you do this is through the sponsorship management system portal. If that is something that you require assistance with, again, that is something we can help with. We do offer tutorials on how to use the SMS system. So if it's quite complex, or you're not understanding how to use all of the features, we do recommend getting in touch with us, because again, this is something that we do know quite well. It is something that we use on a very, very daily basis. So, we kind of know it on the back of our hands, and it is something that we would love to educate everyone on.
Okay, as this webinar is based on the 2023 changes which have happened and have affected the skilled worker application route, certificates of sponsorships have changed ever so slightly with the Home Office and what they require from the sponsor's point of view. So typically what they used to do before is an annual allocation, and you would have to apply for that. Now they have changed their ways in terms of it is an automatic renewal for some sponsors. So again, we would need to assess this on a case-by-case basis. But that is one of the changes that has come into effect with 2023 in terms of the sponsor management system and the skilled worker route. There have been other changes to level 1 users as well, where it can be an automatic upgrade for an individual if they do meet certain requirements. Focusing more on the certificates of sponsorship, as mentioned by ourselves earlier on, we do help with the stock code mapping process as part of our full bespoke package offered at Woodcock Law and Notary Public. And with regards to certificates of sponsorship, and in light of the changes in salary by the Home Office as of 2023, we do make sure that the stock code mapping process is done as accurately as we can. So what we typically advise clients to do is provide us with a job description on their end, just so we have a better understanding of what the role consists of, just because we work with such a wide range of individuals where I, for example, don't know every element of what a butcher does in his day-to-day job role or what a beautician does. So it's always good to get this from the client. And then what our specialist team does is we go through the codes of practice and we assign quite a few different options to the sponsor so that they can choose the best fit in stock code. Along with that, we do ask for various documentation because when we are ready to proceed with assignment, we do need things like a valid passport bio page. Again, something that we have picked up on is the Home Office are starting to crack down on passports which are close to expiry. So we always ask for the candidate to have a passport which has at least 6 months of validity and 2 pages clear. So if they are doing an entry clearance application, they have space to apply the vignette. In addition to this, we do ask for national identity card if applicable, proof of address, just so that we can get the residential address completely accurate, and the UK national insurance number if it is an in-country switch. So one thing I do want to flag up, certificates of sponsorship can be undefined and defined. Defined is for out-of-country applicants, so those that are doing an entry clearance to enter the UK for the first time. One key thing to mention as well, sponsor notes can be made on any live certificates of sponsorship. So for example, if we've submitted an application and we need to make an amendment to the salary or the job title, we can do this by adding a sponsor note. A rule of thumb that we follow here at Woodcock Law, and based on our previous experience, is we only recommend only doing 2 sponsor notes at a time, just because you don't want to flag up potential risks to the application. This is why we go through a drafting process throughout, just to make sure the certificate of sponsorship is as accurate as it can be, and we never assign it until the drafting of the application form is always ready. So we do this simultaneously, side by side, just to make sure both aspects of the skilled worker route is being met and is in line with the Home Office. In addition to this,
okay, so as Pappy touched base on the certificate of sponsorship, and she did mention there are defined certificates of sponsorship and undefined. So this slide in particular focuses on the defined certificate of sponsorship, so that being out of country applications. One thing that I would want to flag at this stage is, whilst the process for assigning a defined certificate of sponsorship is ultimately the same regardless of whether you are in or out of the country, the main difference with that would be that you would need to first submit a DCOS draft, so a defined certificate of sponsorship draft, to the Home Office, which they would then need to approve before we can assign the DCOS. So in a way, it's kind of the safer option, I guess you could say, because the Home Office will have already reviewed the guidance on this. They will have already reviewed that the correct stock code has been selected and the correct salary has been selected. And if it's not, then they would just refuse that sponsorship request, and you'd be able to resubmit a fresh one. The main difference, again, between a defined and certificate is with certificates of sponsorship, you would just be able to go straight into the assignment process. With a defined certificate of sponsorship, you do need to wait the approval of the Home Office first. But if you do want to know a little bit more about this, please do check out our previous webinar, which was based on the sponsor license applications, as we did go into further detail regarding this.
okay, so that is the end of our webinar. So I hope you have understood and are now more aware of the changes which have been made to the skilled worker application as of 2023. We will now open the floor to any questions that you might have if you are watching this live as an attendee today. So feel free to raise your hand, as mentioned earlier on by Helen, and we will be happy to take some questions. Alternatively, you can call or email us at a later stage. So our contact details are on the screen. So again, we will open up the floor for the next 10 minutes to take any questions.
That's lovely. Thank you so much. That was so informative. Can I ask if you could just take the screen down now, please, and then we can see, then we'll see our hands. That really was just so informative. My goodness, you know your subject, ladies.
Thank you.
Right, I can see, I can only see Kenny on my screen at the moment. Do we have any questions? Can I see any yellow hands? Bluefield Solutions, you're on mute.
Yeah, there is a particular question that I want to ask, but offline, but not necessarily for here. So is it something then that we can come back to you on after the seminar? We do have a particular query that is concerning us.
So what we are offering all SELP members, and once we are able to, we will start sharing our slideshow again. We are offering all SELP members a free 30-minute consultation with a member of our team. Typically, our consultations are £350 for a 1-hour session, but again, for all SELP members, we are doing a free 30-minute consultation. So that code will be appearing at the end of the slideshow today after we have done the Q&A session.
Thank you very much for that.
No worries, our pleasure.
That's it. And if I can just say, this will be going up on our YouTube channel, but that takes a few days. And what we can do is just, I'll ask Charlie just to say, everyone who's here today, we'll email out your contact details.
That'd be great. Yeah.
So we'll get that done today, and then the everything you'll appear on the South East London Chamber of Commerce's YouTube channel. There we go. Excellent. Any more questions? But it was so useful, and your slides were just they were great.
Thank you. We do hope everyone has found it useful and informative. We are aware that immigration can be quite a challenging area to navigate, which is why we are here to help and support anyone who is looking for immigration support or just has a few queries about it.
We can appreciate as well, there's a lot of information to take in all at once. So, you know, everyone's situation is different. So, of course, it's always easier just to speak to individuals separately as well, just so that we can get a further insight into their situation and see how we can assist at that point.
Okay, that's excellent. Now, do I have any final questions? No? Well, I'd just like to thank you so much. It's just been so brilliant. I'm going to give a little plug now to the Chamber's forthcoming events. And in fact, you could come to this, ladies, because if you'd like to go to Thackeray Williams, apologies, who sit on our board, their offices, solicitors, their offices, they've got wonderful new offices in Bromley, just outside the town centre. It's really nice there. And we're going to have office drinks. Now, office drinks means that, you know, you go there, you can have a glass of wine or a soft drink. You'll hear about sustainability. We'll hear Thackeray Williams talk, and our office drinks are free to all our members.
Oh, lovely. Thank you.
So that's good. So that's on Wednesday, the 22nd of November. That's 5:30 to 7:30 in Bromley. And again, when we send this out, we'll send out, Charlie will send out these details, hopefully today. And then we can get everyone's brain cells working, because we have our charity quiz night. And our charity is the London Air Ambulance, because we think that's brilliant. And that's going to be on Thursday, the 23rd of November. That's 6:30 till 10 at the Clarendon Hotel. That's the hotel on Blackheath. And then that is not a free event, but because it's a fundraiser, but you do get supper, bangers and mash. And you can come as a team of 10 or a smaller team, or you can join a chamber team if there's just one of you and you want to exercise your brain cells. And then we have our Christmas lunch. We're off to the Bromley Court Hotel on Thursday, the 14th of December. So they're my plugs. And I can say this will be written up in the next issue of our glossy business magazine, Masthead, in January. And I'll ask actually if you'll do a little bit of a write-up for us on this. Okay. But I'll be in touch with you, separately.
Yeah.
Okay, so I think that's been a really informative morning, and thank you so much. We've learned a lot.
No worries, our pleasure. Just before we do go, we just do want to announce, if it's okay for me to share my screen.
Yeah, go on. Yeah.
Perfect. So I did just want to. Can you see my screen okay? If I could just get confirmation for one person to see us.
Yeah, I can.
Okay,
yeah.
Perfect. just gonna go to the next page. So as we mentioned earlier on, all SELC members are entitled to a free 30-minute remote consultation
Yep.
with myself and Roshni, or another member of our legal team. The quote is SELC 30. So if you do let us know that quote, our team will book you in for your free 30-minute consultation. Again, we're more than happy to help individuals in the situation that they're currently facing, and we hope you have found this relatively helpful. Again, we will leave this on our screen for the next few seconds in case you do want to jot this down.
That's super.
And again, a final thank you for watching, and please do visit our website or our contact details for more information. And thank you again, South East London Chamber of Commerce,
Thank you.
for hosting our second webinar with yourselves.
Thank you. And this was our pleasure. Thank you. Okay.
Thanks, everyone.
Okay. Bye-bye,
Bye.
everyone.
Bye-bye.
Bye.
Bye.
Bye.